Good morning, everyone. Good morning. Um, we are about to start. And my name is Charles Levine. I have the great honor and privilege of being chair of the New York State Assembly Judiciary Committee. And I certainly want to thank SUNY Old Westbury, which is one of the great universities, for hosting us this morning. And I want to thank all the folks on my staff for working to help to put this together. So what we're going to do is I'm going to make some short remarks, then we're going to pass the microphone, and everybody can hear me. I think we'll pass the microphone all the way around, and so that everyone has an opportunity to introduce themselves. And then we're going to get to work hearing what the experts have got to say to help us confront this crisis. So as chair of the Judiciary Committee, I'm grateful for the opportunity to hear from so many people working in the front lines of New York's guardianship system, from the courts and legal services to the nonprofit guardians and community advocates. We know that the Article 81 framework was built with the intent to balance protection and autonomy, to protect people who need help while preserving as much of their independence as is possible. But in practice, we have seen the system stretched very thin. Too often, there are New Yorkers who need a guardian and have no one available qualified to serve. That's why conversations like this one really do matter. The Governor's Master Plan for Aging and the proposal to establish a statewide public guardianship office in partnership with nonprofits presents an opportunity to reimagine how we deliver these essential supports and protections. A statewide framework could help ensure that the quality of care doesn't depend on where someone happens to live or whether a willing volunteer is readily available and can be found. I'm not here today to make any promises, but to listen and to learn from your experiences to better understand what's needed on the ground. My hope is that thoughtful discussions like this, which are always very helpful in government, that was a little editorializing on my part and my script here, we can make sure that our guardianship laws and programs reflect the values that each and every one of us share. And those involve dignity, fairness, and care for the most vulnerable of New Yorkers. And yes, in the end, we are all the keepers of our sisters and our brothers. Thank you all for your dedication and expertise. I look forward to a productive discussion that helps move this issue forward in a thoughtful, collaborative way. I am now about to pass the microphone to my friend and colleague, Ed Rock.
Thank you, Chuck. Good morning, everybody. Assemblyman Ed Rock, represent the 19th Assembly District, which is kind of western Nassau County. Actually, when I came in, Judge Diamond asked me if I was on the Health Committee. I used to be on the Health Committee with Chuck for many years, but I served as the ranking member on the Ways and Means Committee. So I think when I saw this on the schedule, there were two reasons why I wanted to be here. One is obviously this is an issue that our constituents are dealing with. We want to hear what's going on, and we want to do what we can to try to improve things so that we can provide the best care and services for these individuals. But second, when you're dealing with the budget, you deal with everything. So certainly these are conversations that always come up when we're dealing with our state budget, and we know that there may be some rough waters ahead. So hearing from all of you very important. So great to be here with you.
Hi, I'm Allison Wininger. I'm a staff attorney at Project Guardianship. You'll be hearing more from me later. Hi, thank you all for being here. Kimberly George, President and CEO of Project Guardianship.
Good morning, everyone. Thanks for being here. My name is Bob Heppenheim. I'm CEO of Guardianship Corp.
Morning, I'm Carolyn Hill, Senior Campus Counsel at Stony Brook University and Stony Brook University Hospital.
Hi, good morning, Danielle Bader. I'm a partner at Abrams Fensterman. I've been in private practice handling strictly Article 81 guardianship proceedings for over 20 years. So thank you for having me.
Good morning, Arthur Diamond, retired New York State Supreme Court Justice Supervisor of Guardianship matters in Nassau County for approximately 8 or so years before my
Morning, everyone. Jason Danforth. I am the Program Director and in-house counsel for EAC Network, National Adult Guardianship Program.
Good morning, everyone. I'm Tanisha Allen. I am the Program Director and in-house counsel for the EAC Network Suffolk County Adult Guardianship.
Good morning, everyone. I'm Andrea Ramos-Copper, Division Director at EAC Network.
I'm Jennifer LeMay, caseworker with the Guardianship Program, Nassau County.
Morning, everyone. Marina Gentil, I'm the supervisor of Nassau County Adult Protective Services and the Nassau County Guardianship Program.
Good morning, everybody. Neil Mukherjee-Lackel, President and CEO of EAC Network.
Tania Peterson-Chandler, Chief Operating Officer at EAC Network.
Dave Cuevas, I am the Bureau Director for Adult Protective Services in Suffolk County.
Good morning, I'm Tara Brolin here on behalf of Senator Martinez. Just gonna listen in and take everything back to her. Thank you.
Next.
Do folks on Zoom want to unmute? Go ahead, Matt.
Here, NYPWA, New York Public Welfare Association. Thanks for having me on via Zoom.
And Matt, you can hear us okay?
Yeah, I can hear you great. Thank you.
I'm not sure if any of the others who have their cameras off want to introduce themselves.
I'm Anthony Barron, a principal law clerk to District Administrative Judge Andrew Krecka in the Suffolk County 10 JD. I'm just observing, so I'm not going to be interacting.
Welcome, Anthony.
Hi.
So I'm just going to give some background and context. As Assemblymember Levine said, our guardianship system is in crisis. Guardianship is also very complicated. So I'm going to try to keep this brief, but it is a nuanced issue to talk about, but I really do want to get to all of the other experts in the room. The system itself has many challenges, but the one we're here to talk about today is the one that needs to be fixed first, because we can't address the other challenges until we address the fact that we don't have enough guardians to serve. There's a number of different reasons for this. It can be because our population is aging. We have a lot more older adults than we do younger children. People are living longer with disability. People are aging alone. People are more likely to face poverty in retirement than they were 20 years ago. For all these reasons, and others, like globalization and families moving around, the judges are in our court system are struggling to find appropriate guardians to name. We have a law in this state that says anybody, any entity, any individual can bring a guardianship petition if they're concerned about somebody else. And the law says once that petition is brought, there must be a hearing and a judge must make a decision. And if the judge from that hearing and investigation finds that the person is not able to manage their daily affairs or complete all their activities of daily living, could come to harm because of it, and lacks an understanding of the harm that they could come to, then the judge must appoint a guardian. But who are they going to appoint? Family and friends is who should always be appointed if there are family and friends to serve. But in a growing number of cases, there are not. Our system allows for a list of fiduciaries called the Part 36 list to be appointed when there is no family or friends to do it. The Part 36 guardians get paid out of the money of the person who needs the guardian. So if that person has no money and has no family or friends, the judges have nowhere to turn. Over the last few decades, nonprofits have filled this gap in our system throughout in pockets of New York City, not everywhere. But we struggle. We're cobbling together funding all the time. And it means that we're spending so much time and energy keeping our doors open. And many of us have to contemplate closing our doors at times. And this leaves the people that we're guardian of in a very bad situation. However, nonprofits have proven that with sufficient public funding, we can deliver person-centered guardianship, which is the type of guardianship that the assembly member was talking about at the beginning, about keeping the person with as much autonomy and self-determination as possible. Nonprofits, we staff multidisciplinary teams with specific skill sets, not just in the law, but also in social work and benefits access and housing access and financial management. And our teams can come together and provide the level of care that our neighbors deserve. We've also shown that nonprofit programs save over $67,000 per year per client, mostly in Medicaid savings, also a little bit in shelter avoidance. And that's after deducting the cost of their home care services, mostly by avoiding institutions, deducting what Medicaid will be paying and deducting the cost of the nonprofit guardianship provider. They're still saving $67,000 per year per client. This issue we've known about for a long time. There was a roundtable back in 2018. There's a write-up about that in your packets. If you want to read about that roundtable, almost 8 years ago. And it resulted in funding for 2 pilot projects here in Long Island, one in Nassau and one in Suffolk. I'm not going to speak about them because the founders of those programs are in the room and they're going to testify. But I will say that the funding, the need was recognized, and then it wasn't funded again. It wasn't studied, it wasn't expanded. We sort of moved on, which is a big problem and why we're back here today. A few years ago, some of us nonprofit providers and advocates and stakeholders got together and formed a coalition called Guardianship Access New York. We call ourselves GAN. We've been advocating with our legislators for a few years that there needs to be public funding so that everybody who needs a guardian has access to a good, high quality, person-centered guardianship. This did result in some money for a couple of years in a row, but it's money partly to fund a helpline, which has proven to be a huge need and hugely successful. There's a flyer about the helpline in your packets as well, because you, the elected officials office, your constituents, anybody can call this hotline about somebody living in New York State and talk to an attorney almost immediately. And it can be guardianship adjacent, it can be guardianship avoidance, it can be, is guardianship the right tool for me? It can be about elder care. We will answer the call and get you to the appropriate person that can help you. That funding that we've gotten 2 years in a row now is funding guardianship services for 36 people. That's not enough people. And so we need to help thousands of people with these services. A lot of the calls that the helpline is getting, most of them are coming from New York City. We're trying to market to the rest of the state, so please tell people about the helpline that they can call it. The number of people calling from Long Island versus the number of people calling about somebody on Long Island is double that the people that are getting called about live on Long Island. They could be calling from, we have somebody calls from another country about somebody living on Long Island. The other thing that I will say before we turn it over to hear from everybody in the room, as the assembly member mentioned, the state's master plan for aging has guardianship in it. Thank goodness. And it does mention $15 million for nonprofits is needed to fill this gap. The MPA also says that this issue of guardianship and nonprofits filling the role is high need and high feasibility. So it really is something that we should be funding and paying attention to. We also sent a sign-on letter to the governor that had over 30 stakeholders, community groups, member organizations from across New York State that signed on to this letter. So we're happy to share that as well. And so with that, I am going to turn it over to one of our chief experts in the room, Honorable Artie Diamond.
Thank you, Kimberly. Thank you all for being here. I'm going to start by thanking Chairman Levine for taking the time over the past 2 years to get educated about these issues. You're incredibly generous with your time. Even had lunch with me where I spoke for 2 hours nonstop about this. And I'm very grateful that you have remained interested and continue to be supportive of what we're doing. So, and thank you again also to Assembly Member Rock for taking the time to be here. Very grateful for that you took the time. So that's the good news. The bad news is that, as Kimberly alluded to, I've been here before. In 2018, at my urging, then Senator Kemp Hannon was chair of the New York State Health Committee in the state Senate, convened a roundtable in Albany with judiciary and health stakeholders. That meeting is on the Senate YouTube channel. If such a thing really exists, but it's there. I was the first witness that day in 2018. And I made it clear then at the time that guardianship was in a crisis. Obviously, I was on the bench then, I retired in 21. And I indicated to the people who were present that we were running out of people who were willing to, attorneys who were willing to serve as guardians. And at the time, for attorneys to serve as guardians, that era, in my opinion, was over, and that we needed to find alternate ways to create a guardianship pool, because the aging population in New York was the fastest growing, still is. By 2030, I remember I said this in 2018, by 2030, there will be more 80-year-olds than 5-year-olds in New York State, which is an astounding number in terms of the amount of money and support and services that people who are 80 need to live in New York State. But the message from my time on the bench of attorneys, and Ms. Bisbee will attest to this, I believe, is that the cases will become too complicated, too time-consuming to repeatedly take on pro bono, because we simply had no other people to serve. The enticement that we used at the time was to tell attorneys, if you take this case, the next paying case, will be sure to do our best to give it to you. So the attorneys soon realized that the next paying case never comes. And so over time, between then and now, the number of attorneys refusing appointments has increased dramatically. The situation vis-a-vis the public guardians, the contracting for public guardians, is the same as it was in 18, but worse. And by that I mean, even though we have PAC and NASA who've done a spectacular job, they always have, they cannot handle the number of attorney rejected cases because they simply don't have the stick. Nonprofits are overloaded. I'm a member of the Guardianship Access and Board. I'm a member of the Second Component Roundtable. I'm a member of the Chief Judge's Guardianship Advisory Committee. In every one of those meetings all year long, all of the nonprofits from around the state say, we are rejecting cases every day because we can't handle them. I made it clear then that OCA and the legislature and the governor's office have really abandoned the judges who do this work. And every judge in the state, and I know because I interviewed about 90% of them for the new chief judge when he came in, every one of them feels that the work they do is unsupported by the state. There is absolutely no support in getting funding, that there hasn't been to this point. Now, when Judge Zayas came in with Judge St. George, I lobbied them a year ago about this, about OCA's ignoring the situation that the judges had in the courtroom. And they did include this year for the first time, $500,000 dedicated to guardianship. So we're grateful for that. I hope it's a beginning, but the reality is it's a drop in the bucket. This is a problem that requires, several $1 million. We spent last year, the last 2 years, Danny spent hundreds of hours lobbying our legislature. Both of you in the room are aware of that. And the result of several years of that lobbying was a grant of, as Kim said, $1 million 2 years ago, which has been used to fund the hotline cases. That's $1 million out of a budget. Assemblyman Rock corrected $254 billion. $254 billion. The failure of government in the court system to address what's going on with guardianship is a disgrace. It is shameful and embarrassing that judges have to beg lawyers to work for free in order to protect these people who rely on us for services, for protection, for shelter, for financial management, and I can go on and on. It's really time that the state understand and the governor's office understand what's going on here, and having the two of you here will hopefully be a small but certain first step in getting us where we need to be.
Thank you, Judge Diamond. Good morning, everyone. I am CEO of Guardianship Corp. Guardianship Corp is a non-profit that I formed in September of 2018 as a result of two almost simultaneous actions that occurred throughout that year. The first were discussions with then presiding guardianship Judge Horowitz in Suffolk County, who in a meeting explained to me his difficulties trying to find responsible people to step up and act as guardians for individuals without family, friends, or neighbors willing to step in and take on this important role, and or they lack the funds to pay for a guardian. As he presented, more and more cases were and remain being presented to the court from nursing homes, hospitals, adult protective services, and others that in compliance with Article 81, once someone is declared incapacitated, legally require appointment of a guardian to spend the time and attention to assist and guide a frail, incapacitated person so as to ensure their welfare is not in jeopardy and that the plans for their ongoing life are reasonable and safe. The other critical action was, as you heard, there was a joint Senate roundtable held in January 2018, and it is available on YouTube. I have seen it and can send it to anybody. The result of that hearing, as was mentioned, was $500,000 in funding. 250 went to Nassau County, 250 came to Suffolk. That's what formed the initial funding for Guardianship Corp. Our mission was at the time a volunteer-based program that sought to provide increased visitation and support of clients while keeping costs to a minimum. Guardian Corp's mission is to provide high-quality, cost-effective, and ethical services in the performance of duties as court-appointed guardian for the indigent of Suffolk and Nassau County. After COVID, we moved away from a volunteer model to a small paid staff of 4, currently serving 65 clients in Suffolk and Nassau. Since 2018, we have been appointed to over 150 cases. Our clients are as young as 19 and as old as 100, with Alzheimer's, both early and late onset, as well as other types of dementia, autism, multiple sclerosis, developmental disorders, mental health disorders, traumatic brain injury, just to name a few. All of these conditions contribute to a person's inability to care for themselves. Many of the applications are made by hospitals as a result of someone being in a coma or dementia with no one to make decisions to facilitate their Medicaid replacement, or sometimes they languish in a hospital bed for months, waiting for someone to take the wheel and make the necessary, compassionate, critical medical decisions for those unable to speak for themselves upon our appointment and for the rest of their lives. Some appointments are for a successor guardian, meaning that their original guardian or family member has died or can no longer act. Others result from dysfunctional families fighting over a parent or assets. Most are sadly frail individuals, failing alone, with no one looking out for them in the community until they end up in a hospital, unable to be safely discharged home until someone is appointed to make sure that a safe discharge is coordinated and that their ongoing safety is assured, and ultimately that they are buried with dignity. My lessons learned from 7 years in guardianship. One, that the life cycle of these cases can span years. We still have a number of cases that we were appointed to in 2019, and will live for another 10, 20 years, hopefully healthy. We do have an average case longevity of 2 to 3 years, as many of our appointments pass away within weeks or months of our appointments. Depends on the client's age, their diagnosis, and their acuity. Our more recent cases have skewed younger and or more challenging, but we respond to the court as we can. 2, courts work very hard to ensure that each individual's rights are protected and that each alleged incapacitated person is treated with dignity and respect. Each order and judgment is specifically tailored to each person's individual needs, with no power granted unless reasonable and needed for a specific case. It is our privilege to try and provide solutions to their most challenging cases. However, it's also become clear to me that guardianship is 10% legal and 90% social services. The legal part is all upfront. The process being declared incapacitated, the process of identifying who should be that guardian, what their powers should be, all of that's highly legal. But once the baton is passed to a guardian, it is all caring for somebody sick, frail, needing decisions, needing to look out for them to make sure that they are safe. Third, guardians cannot fix everything. Often by the time we are appointed, the situation we find our ward in is fixed, meaning we can't change their diagnosis, the history that brought them to need guardianship, nor the residences, care systems, or agencies that exist to support them. We can advocate, monitor, and be proactive in our approach, and work diligently towards the best interest of each client where we find them. 4, the demand for our services from Suffolk and Nassau remains high and constant. This year, we have accepted 31 new cases, and our caseload is currently full. And lastly, the biggest challenge, besides the direct hands-on managing of other people's lives, has always been funding. We are currently funded by Suffolk County Department of Social Services primarily for up to 50 cases, for which we're very grateful. We have 2 smaller grants covering other cases. It's hard to concentrate on caring for others when you're not sure that you're going to exist next year. In closing, we have successfully created a working model to service a critical need for the county, the courts, and our community that is cost-effective and driven by quality. I call upon the elected officials across New York State to find a way to support and fund non-for-profits doing this important work in a stable, sufficient, and reliable manner so that we may continue to be a valuable resource to the poor, frail, and voiceless of the state.
Thank you, Bob. And while we are going to consider and should consider who's going to count for the caretakers, let me just say we've been joined by my friend and colleague, Assemblymember Chief.
Morning, everyone. My name is Tanisha Allen, and I serve as the Program Director and In-House Counsel for Suffolk County Community Guardianship Program at EAC Network. EAC is a non-for-profit organization that empowers, assists, and cares for individuals in need across Long Island and New York City. Thank you for allowing me to speak today about the critical work that our program does and why continued funding is essential to protect some of New York's most vulnerable residents. Our program serves as the guardian of last resort for individuals who have been deemed incapacitated under Article 81 of the Mental Hygiene Law. These are people who typically have no family, no friends, and no one else willing or able to take on that responsibility. Many of our clients are elderly, disabled, or medically fragile, and come to us after years of neglect, financial exploitation, or abuse. When the court appoints us, we step up to stabilize their lives, ensure their safety, and restore their dignity. Our guardianship work is centered on protection, prevention, and compassion. We intervene in situations where neglect or abuse might otherwise go unchecked. We make sure our clients have safe housing, appropriate medical care, access to benefits, and advocates who can speak on their behalf. In many cases, we are the only people regularly visiting our clients and ensuring that their needs are met and that they are treated with respect. Without community-based guardianship programs like ours, individuals in need of guardianship often remain in hospitals or nursing facilities for extended periods simply because there is no one to coordinate their discharge or manage their financial affairs. Those delays not only diminish quality of life, but also place a significant strain on our healthcare system. By taking on these cases efficiently and responsibly, we help reduce unnecessary institutionalization and free up the hospitals and state resources. In the past year alone, our program has supported a caseload of over 100 clients throughout Suffolk County. We work closely with the courts, hospitals, nursing facilities, and social service agencies to create individualized care plans that balance autonomy with protection. For example, we recently assisted a client who had been hospitalized for months because he had no family or anyone to assist with his care or finances. Once our program was appointed, we obtained his benefits and safely transitioned him into a group home that addressed his medical and daily living needs. We also had an elderly client who was being financially exploited and facing eviction. After our appointment, we stopped the exploitation, assisted with the eviction process, and secured placement in an assisted living facility where she now receives the care she needs while maintaining her independence and quality of life. These examples reflect the everyday reality of our work, but none of it's possible without stable and sufficient funding. Guardianship cases are complex and time-intensive. Our multidisciplinary staff handles every aspect of our clients' lives, which includes medical decisions, financial management, benefits coordinations, housing, and other end-of-life care. Each case requires compassion, skill, and persistence. Adequate funding allows us to recruit and retain qualified staff, maintain compliance with court mandates, and ensure that every client receives the advocacy and attention they deserve. Adequate funding will also ensure that community guardianship programs are equipped to meet the needs of our rapidly aging population, which continues to grow every year. When you fund community guardianship programs, you are funding safety, dignity, and humanity for those who have no one else. You are ensuring that a safety net exists to protect vulnerable New Yorkers from exploitation, neglect, and unnecessary institutionalization. On behalf of EAC Inc. and the Suffolk County Community Guardianship Program, I respectfully urge you to continue and expand your support for community-based guardianship services. With adequate state funding, we can continue to protect the most vulnerable among us and relieve pressure on the courts and healthcare systems. Thank you for your time.
Hello, everybody. My name is Jason Danforth. I am the in-house counsel and the program director for the EAC Nassau Guardianship Program. Actually, I am Tanisha's counterpart in Nassau County. I am extremely proud of the high level of care we have been able to provide for some of our county's most neglected and also most vulnerable clientele. Our multidisciplinary staff, consisting of the very best professionals within social work, elder care, and law, are able to provide a wide array of services which are unprecedented in the area of guardianship, including finding proper housing, social services, medical and psychological care placement, and whatever other needs are necessary to meet the needs of the client, even if it's just meeting with them and providing care and providing guidance to somebody who is a vulnerable person. However, although our department is equipped to take the most challenging cases, in order for us to continue to properly meet each client's diversified needs, it is essential that we do receive the government funding that is necessary to ensure that our program can continue to grow and provide the higher standard of care for our aging population. Our program now is proud to serve over 100 clients. Recently, we had a very large expansion, which went quite well, where we almost doubled our caseload. And many of our clients, they continue to reside in group homes, in nursing homes, as well as within the community. These clients require a large amount of program work, including staff assessment, comprehensive service planning, regular visits, ongoing support, and also extensive reporting to the court. All of our staff have been trained in Article 81 proceedings and are able to properly communicate with the court. But as our community continues to grow, the need for competent guardians also is growing. Most of our cases lack either family members or friends, or our clientele do not have the funds to ensure that a proper guardian is placed in order to manage either their property or their personal needs. EAC does come in and is able to handle many of these clients which suffer from dementia, from autism, or other mental health disorders. And these cases are often hostile. They're often hostile to our appointment, or they are hostile to the need of a guardian in general. So what we are asking is for the continued funds to be given to us so that we are able to serve all clients that are in need and do not need to turn away anybody who's in need of our services. Thank you very much.
My name is Allison Winninger, and I'm a staff attorney at Project Guardianship for two of our multidisciplinary teams. I'm going to share today two client stories that highlight Project Guardianship's person-centered approach. The first story is about a client who I'll call Miss A. Miss A is an older adult with blindness, profound hearing loss, and an intellectual disability. She became our client almost 10 years ago when Adult Protective Services filed a guardianship petition because of evidence that her young adult son was verbally and financially abusing her and threatening her home health aides. APS had initially become involved several years before that when a gun allegedly belonging to Miss A's son was found in their apartment and her home care services were consequently terminated. When APS filed their guardianship petition, Miss A was living in a 2-bedroom Section 8 community apartment with her son, his intimate partner, and their infant child. Miss A's son and his nuclear family slept in one of the bedrooms and illegally rented out the second bedroom, relegating Miss A to a mattress on the floor in a small alcove off the living room. In addition to the accounts from Ms. A's home health aides of her son's aggressive behavior and financial control,
Ms. A was also at risk of eviction because of the illegal sublet. Ms. A was admitted to the hospital soon after our appointment and discharged temporarily to a nursing home. Her son was evicted from the apartment and disappeared from her life, and we eventually secured Ms. A an alternate community apartment in a Section 8 building for people with blindness. Fast forward about 9 years to last December. I received a call from our case manager who had just completed her monthly home visit with Ms. A. She discovered that Ms. A's son had moved into her apartment several days earlier. He was intimidating and harassing her home health aides and calling her home care agency to ask that certain caregivers be removed from her case. We arranged for the locks to be changed, and I spoke with Ms. A's son to explain that he was not permitted to live in the apartment or interfere with his mother's home care. I sadly could not reason with him, and it became clear to me that his reality of the situation was very different than our reality of what was happening. He truly believed that Ms. A's home health aides were poisoning her and that he was protecting her from them and a government conspiracy. The trouble was that the actions that he viewed as protective were jeopardizing his mother's specialized housing as well as her physical safety. And while Ms. A told our case manager that she wanted her son to stay, we reached the decision that it was critical to her health, safety, and overall well-being for us to intervene against her objection. I somewhat reluctantly filed an emergency motion for a temporary restraining order and order of protection. I say reluctantly because as a former public defender, I've never wanted to be in the business of creating pathways to incarceration. But I was also optimistic that with thoughtful litigation and collaboration, we could end up with a carefully crafted order that considered Ms. A's desire to remain connected with her only son while ensuring that she was able to continue living safely in the community. At the initial hearing on the motion, the judge entered a temporary order of protection that allowed Ms. A's son to have supervised visits with his mother. We went back to court 4 more times over the next several months to extend the order of protection of supervised visits until eventually we agreed to lift the order of protection and enter a permanent order that allowed full contact between Ms. A and her son, but prohibited interfering with her home care and other aspects of her life. That went well for a while until it didn't. Fast forward again to the spring, and I received another call from our case manager. Ms. A's son had moved back into her apartment and was interfering again with her home health aides, using her debit card and not allowing Ms. A's boyfriend to enter the apartment and organize Ms. A's medicine. He was in violation of the order of protection and again creating an unreasonable risk to Ms. A's health, safety, and welfare. I called Ms. A's son, and he told me that Ms. A's boyfriend was not allowed in the apartment because he was involved in human trafficking ring and that dozens of drug dealers were entering the apartment each day to chain his mother to a chair. This was all contrary to Ms. A's home health aides and our case manager's observations that Ms. A and her boyfriend had a loving and consensual relationship that brought Ms. A great joy. But we of course checked out the allegations as we had before. This is there's 24-hour security in Ms. A's building, and all visitors are required to sign in and out of the building. So we spoke with the building manager who confirmed that Ms. A's caregivers, boyfriend and son, and our case manager were the only visitors. They also reminded me that having someone live in the apartment who was not on the lease was a violation of Ms. A's tenancy. Ms. A's son said that he had to protect his mother and that he had nowhere else to live because he had recently become homeless. While I was sympathetic to his situation, I knew that we had to again intervene. I filed another emergency motion for a restraining order and obtained a permanent order of protection that prohibited Ms. A's son from interfering with her home care, finances, and personal relationships, but allowed him to visit with Ms. A in the common area of the building. It was a good result that protected Miss A in the least restrictive way possible, and it considered Miss A's safety from a holistic perspective that included her emotional well-being and safety. The second story I'm going to share is a shorter one, although I will say that my daily phone calls with this client are anything but short. It is about a client who I will call Miss S. Miss S also happens to be an older adult with low vision who has been our client for many years. She has a very challenging personality and lives with untreated mental health conditions that often result in her yelling and using offensive language. She struggles with emotional regulation and anger management, and she is easily triggered by a perceived loss of control. She is also brilliant, thoughtful, and very funny. She attended an Ivy League university, is a talented singer-songwriter and pianist who in her younger years published an album and used to perform stand-up comedy routines in the village. Ms. S.'s sister filed a guardianship petition when Ms. S. was facing an eviction proceeding because of the condition of her apartment. At the time, Ms. S.'s life had spiraled out of control as the result of depression and other mental health conditions. Ms. S.'s sister was unable to work with Ms. S. to declutter her apartment or put home care services in place. And it also became evident that Ms. S. was unable to manage her own finances. A narrowly tailored guardianship order was entered in which Ms. S. retained authority to make medical decisions for herself. The court initially appointed a private guardian off of the Part 36 list and later appointed us as successor guardian, in part because managing Ms. S.'s case was too time-consuming for a single practitioner. This isn't one of those client stories that can be neatly wrapped up with a bow. People's lives can be complicated. I would love to be able to say that Ms. S.'s life is stable and she's now connected with mental health care, but I can't say that. There are ups and downs, successes and failures. Just when I think we're moving forward, we take 2 steps back. What I can say is that in the world of guardianship, where it can be easy to compromise dignity and autonomy, we have been able to use a person-centered, trauma-informed approach to keep Ms. S in her home and protect her safety and well-being from a holistic perspective. We have engaged in supportive decision-making with her and avoided motion practice to expand our powers when possible, even when that would have been easier and faster. Last winter, our case manager called me and said that she had heard that Miss S's leg was infected and there was possibly cellulitis. We knew that as a diabetic, this could possibly be a life-threatening condition for her. Ms. S did not want to go to a doctor because of previous medical trauma. And we knew that if we were to expand our powers and try to bring her to the hospital against her will, it would be emotionally dangerous for her. And we persistently coaxed her, and she eventually accepted an in-home doctor's visit. Eventually, with our support, after over a year, she left her apartment and is now actively engaged in the community and with healthcare. It's not a happy ending. Our work is still ongoing. Just this morning, I received a phone call that Ms. A was not accepting home care Ms. S was not accepting home care services again. We're continuing to work with her. But our person-centered approach is bringing dignity to her.
Thank you, Allison.
Hi, again, I'm Danielle Fitzbader. I work at Abrams Fensterman. I've been there for a little over 21 years now. And I work exclusively in the Article 81 Guardianship Department. I think I have a unique perspective to offer here because I see these cases from both sides. I see them as the attorney who's seeking to have a guardian appointed, and I see them as the court-appointed guardian. I'm on the Part 36 list. I currently have 9 wards, which doesn't sound like a lot, but trust me, 9 wards is actually almost a full caseload for a practicing attorney like myself. 5 of them are no asset cases out of the 9. 2 of them we consider low asset cases, which means that there's some money there, but I need to reserve it for a burial someday. And that's a challenge, right? Because I have no asset cases and I need to find a way to bury that ward when the time comes. And 2 of them we consider to have assets where we expect the firm to be paid for my services. I work on a team of 15 lawyers at Abrams Fensterman who all work in the Article 81 guardianship practice. Only 2 out of the 15 of those lawyers are still accepting appointments as guardian. And that's not because there was any directive from the law firm, not to take them. It's because the attorneys personally felt that they were too overwhelming to take these cases. They are very complicated, especially from the front end, immediately upon appointment. The number of hours that go into trying to get the case just stabilized. It could take several weeks of full-time work from an attorney or a paralegal to simply get identification, social security numbers, access to whatever benefits they have. And it's a lot to take on. I file on average somewhere around 80 to 90 petitions on behalf of our nursing home clients. We have a large nursing home client base, and 80 to 90 a year. I sat down with my paralegal last week to come up with a number of how many we thought were no asset cases. And we believe almost half of those cases that we're filing on behalf of the nursing home are no asset cases where only Social Security or SSI is the income source and nothing else. Who wants me to tell you what a petition is? Okay. In order to get into court with the guardianship proceeding, we file a verified petition, which, lays out all the facts of the case, and it explains to the court, the judge is going to hear the case ultimately, why we need a guardian, what the need is for the guardianship, and we just lay out all the facts for the court. And on a lot of my cases, when I get to court on the day of the hearing, I'm sitting before a judge or a law secretary who I see all the time because I'm there regularly. And they're saying to me, listen, this person needs a guardian. You're going to meet the burden of proof, without a problem. Kind of like what Bob was saying, it's 10% of the work is legal, right? It's obvious. And they look at me and they say, but I have nobody to give you. Can you figure out another way? How can we work around this? Can we limit it? Can we do a court order, single transactions kind of process? So the judges are put in a position where they know that the individual needs a guardian to meet their needs, but there just is no guardian to appoint. And this happens all the time, multiple times a week on my cases. And when I act as guardian, the flip side of it, I have judges who, again, I'm booked for all the time, and they call me up and they say, Danielle, will you take this case? And I remember one story in particular, which I think is so telling. A judge who I still appear before now called me, and he had a case and he wanted me to take it, no money case, and said, oh, it's not that much work, just please take it for me. And, similar to what Judge Diamond was saying, just take it, we'll get you another one. And I said to the judge, I said, listen, I have 12 wards right now. It's not that I don't want to take it. I don't think I have the bandwidth to take it. And he said to me, I'll take you with 50% effort. I just need somebody. So I took it. Why do I still take these cases? I take them because I do feel an obligation to give back to the court system that I'm in all the time, asking to help my client, to help me achieve an end goal. So I still take the cases. 2 cases in particular I wanted to mention today. I have a ward named Elizabeth. I have been her court-appointed guardian for both the property and the person, even though her property is nothing. All she has is SSI income. She lives in subsidized mental health housing in Oceanside. And I've been her guardian since 2006. And I have received not $1 for being her guardian. It's fine, I knew that when it's the case from the judge who called me. But I can't take too many of those, right? I can't take too many of those cases. And Elizabeth is down in Oceanside and she's in subsidized mental health housing. She goes to the hospital and gets her treatment. Hasn't been hospitalized since she met me. I meet her 4 times a year at a diner in Oceanside for lunch, because I'm obligated to see her 4 times a year. So I do that. But it's 20 years that I've been her guardian, and she was 48 when I got the appointment. I have another ward named Devin. He's 36 years old. He's in Brooklyn. The judge in Brooklyn knew me. I practice in Nassau, Suffolk, Queens, Old Boroughs, Westchester. The judge called me up, please take the case. His mom passed away. His mom was the guardian. He's in a group home in Brooklyn. His mom passed away. He has no one. He has no money. Please take the case. I took the case. So I'm his guardian. I go to Brooklyn 4 times a year to see him. I do the annual accountings, which I think a lot of people here were saying it's time intensive, and it is. It even is on cases with no funds. You're still obligated, if you're unaware of this, but you're still obligated by statute to file annual reports and accountings, even if there's no money. You're still obligated when that board passes away or no longer needs a guardian. You're still obligated to do motion practice. So now there's cases, no funds. I'm the guardian. To get off the case, I need to file a motion. I need to file an accounting. And I need to wait for the court examiner to review it, or the court clerk to review it, because these are no money or little money cases. But still, for the attorneys in the room, you know that that's time intensive, it's labor intensive, but you have to go through it. Another thing that I think is interesting from a court-appointed guardian perspective as an attorney, I have 3 children, and I have taken 3 maternity leaves in my career. I also took some time off last year for a personal family matter. I didn't have to work on any of my cases during those times, except my guardianship appointment. And my paralegal and I discussed, do we get a temporary to fill in for you? No, because by the time I file a motion to get a temporary, I'm gonna be back. It's gonna take at least 90 days to turn it around, and I'm gonna be back in the office. So I'm just gonna continue to, do that work while I'm out on leave. And even after a death, right? So now you're not working on the case anymore actively, but you filed your motion to be relieved due to death. Those filings can sit for years. So you're still on the case. So as a practicing private attorney, that's a problem, right? It's like the only area of the labor force where you can't ever stop working. You can't ever get out of the case. And so that's problematic. A lot of my colleagues are not taking these cases anymore. The Part 36 list has 100 and something names on it. Most of them are not actively taking cases. Or judges call them and they reject the case. So it's a real problem. And I also think, to follow up to what Bob was saying about it being 90% social work and 10% legal, lawyers really aren't the best choice, right? I'm not the best choice to be a guardian. I have no training in social work at all. Isn't a properly funded community guardian the way to go, where they can have social workers on staff, where there's a team of people and it's not just myself and my paralegal while also juggling the full case docket? It just seems to me that that's the better way to bring care and service to these individuals who need it. I'll tell you, on my cases with money, I always hire a geriatric care manager to come in who has a social work background, because that's really the best way to go. So these individuals that don't have the funds to pay privately for that, they should get funding from the government to do so. And thank you for having me.
I believe Dio is not here, so. I'm Carolyn Hill, I'm Senior Campus Counsel with Stony Brook University and Stony Brook University Hospital. The primary focus of my job is to bring petitions on behalf of hospital patients at Stony Brook who have no way to get out of the hospital other than with the guidance of a guardian. I would say 98 to 99% of those patients that I work with do not have any financial resources. They rarely have any family members that are able or willing to become their guardian. So primarily, the burden falls upon either Guardianship Corp or EAC, and that is it. Those are the only resources we have available. And I know is almost always, at his full capacity. EAC is almost always at their full capacity. But Bob in particular, I'm sitting in judge chambers and they call Bob and beg him, and he always says yes. And we are so appreciative of that, because I know how stretched his resources are. But otherwise, these patients wind up staying in the hospital. Now, the cost of a hospital bed for a patient to be laying in a hospital bed for a day is over $7,000. And these patients are, because there are no alternatives for them, wind up staying in the hospital 3, 4, 5, 6, 8 months, a year, longer than they need to be for any health-related reasons. I will say, when I report back to our social work staff, those are the ones who are primarily involved with the patients on a day-to-day basis, when I report back to them that Bob has been appointed, they are so happy. They know he gets the job done. They know he will be there with compassion and care for these patients, and that he will act quickly to get them out of the hospital as soon as he possibly can. Without resources, organizations like Guardianship Corp, EAC, patients remain in the hospital much longer than necessary, and results in poor health outcome for these patients. They're exposed to potential infections and bed sores and things that, with proper care in a proper setting, should not happen. I think Bob mentioned he's budgeted for 50 cases a year. We're one hospital in Suffolk County, and this year I filed 14 guardianship petitions. I have 4 sitting on my desk, and probably another couple before the end of the year, which means I'm taking up almost half of Bob's resources, if you look at it in that regard. And the increased cost to the system as a whole for patients remaining in the hospital, when there are alternatives that should and could be utilized, it's insane. Not to mention that Article 28 hospitals such as Stony Brook were not licensed to keep patients for any type of residential or long-term care. In general, even when there are family members who care about the patient, they're either unable to physically take the patient back to their home situation because they're working, or just physically cannot care for the patients. The cases over the past 5 years, I would say, particularly since COVID, have become so much more complex. My understanding, my belief is that a lot of that has to do with cuts in services as a whole, all types of different services that are no longer available to patients that could have used services to remain in their home. But agencies like EAC and Guardianship Corp provide the highest levels of guardianship, maintaining dignity of patients and giving them the least restrictive options possible. And their services are absolutely essential to what we do as a hospital, and to the most vulnerable of our citizens.
Thank you, Carolyn. Jennifer, or anybody from APS or DSS want to say anything?
Actually, I wasn't planning on saying anything. I was just here to basically listen. But in hearing what everybody is saying, it really is an important need that needs to be filled. One of the things that I've learned through life is ignoring a problem doesn't make it go away. Some of us have learned that the hard way, some of us still haven't learned that lesson. But I think it's important to understand, we're talking about different situations as far as guardianship, and from an APS perspective, our goal at this point is, we want to use the least restrictive alternative and make every effort to maintain individuals in the community. Sometimes, unfortunately, we're unable to maintain those individuals in the community, and we may have to look at placement options, et cetera. So we deal with a lot of cases. I've worked closely with Tanisha and some of our guardianship cases. We've actually done the presentation together on guardianship. But I want to kind of point out, it's important to understand why this is so difficult, because it's essentially when there's the people that are institutionalized, with the hospitals or the nursing homes or filing for guardianship. And it could be reasons because if they're in a rehab, they're 100-day Medicare part has run out, and now they need more of a permanent situation, and they need to apply for Medicaid. Could be somebody who's in the hospital, there's no medical reason to keep them, and therefore they need some sort of guardian appointed, whether it be to help them get on Medicaid, whether it be to work out some reasons for them to be discharged, et cetera. From APS perspective, oftentimes we're filing for guardianship because we need to try to address some issues in that individual's life, whether it is to maintain them at home, and in some situation, it may be because we need them to be institutionalized. So the people that we're talking about, basically, they can come from any socio or economic situation. So Danielle mentioned that some of her clients are indigent, don't have a way to pay. There's also those clients that we've had people that we filed for that have millions of dollars, so there's a whole array of situations that are met in terms of the need of guardianship. So it's not a respective person as far as the need for it. So the rising concern, one thing that I haven't heard mentioned, one of the rising concerns as far as a lot of the individuals that we're looking in guardianship for is this rising concern of exploitation or being vulnerable to exploitation. It's funny because there's been more and more things on the people that are doing the, I get spammed all the time that Easy Pass, I get spammed all the time on the warranty for my car. I get spammed all the time on all these things that people trying to do all these exploitation scams. And a lot of people that we're dealing with, that's an issue. So there's the financial, whether they're being easily victimized as for financial exploitation, whether they lack the capacity to make decisions regarding their finances or whatever that may be. But in the end, I'm going to kind of talk more from an APS perspective. I've been in APS for 36 years. I've been the director in APS in Suffolk for about 6 years. So to me, our goal at this point is we're looking to maintain people in the community. Hospitals are looking either to get people back home or get them placed in an appropriate facility. But in the end, we're all faced with the same challenge. It's an increased demand of people who need guardianship appointments, and there aren't enough people out there that take on these responsibilities. We've worked with EAC, and specifically with our cases, they're complex situations. You're dealing with families that may or may not be able to care for anymore for those individuals. You're dealing with mental illness. You're dealing with issues of abuse or neglect. You're dealing with poor housing conditions. You're dealing, as I mentioned just a second ago, concerns of exploitation. So kind of to Danielle's point, these are not situations that most attorneys are necessarily equipped to deal with. So in many ways, I think Bob had mentioned this, that it's like we've kind of turned from that era where we can easily hand these off to attorneys, well, or not so easily recently, hand off these things to attorneys and expect them to be able to meet these needs, because the needs have been more and more complex, they've been harder to address. And we need people that not only are able to provide the legal expertise needed to deal with that stuff, but they deal with the social work part of it, because you're dealing with people that, for lack of a better way, oftentimes need to be handled a particular way because of one reason or other. There's all kinds of situations, whether it be a pet, whether it be the housing, whatever it is. So, I just do see a great need for this. I know that, like in Suffolk County, part of the issue, as I see it, is that, you know, it comes down to who's gonna fund it. Is it gonna be the counties, is it gonna be the state, is it gonna be the federal government? And I think that it has to be something where we have to come in agreement on, make it a mutual approach, okay, where right now we're looking for state funding, because the reality is at this point, whether it be at the local level, whether it be at the county level, whether it be at the state level, there's not a lot of money there. There's only a certain number of dollars that's there in the pool that can be kind of used. But I think what's being said here, what's being pointed out here, that if we don't address these issues, all right, in the long run, it's gonna cost more money, because whether it be because of Medicaid expenditures, because of the incarceration or whatever. I think whether it be at the federal, well, not so much the federal, but the state, or the local level, it's just gonna cost us more money if we don't really try to address the problem at this level and deal with something in a manner that where we can address these individuals with respect and dignity, and try to maintain them in the community whenever possible. All right, and kind of address these through a guardian, more from like a community-based guardian, as opposed, or not-for-profit, as opposed to, in no offense to the attorneys, as opposed to always having a list of attorneys that are handling these.
Can we write this follow some 2 minutes?
Yeah, and I actually wanted to see if Matt's still with us, to give New York Public Welfare Association's perspective. Why don't we let Matt go, and then I'll come over to you, Artie.
Hey, great. Thank you so much. Yeah, again, my name is Matt Barron. I am the Communications and Policy Director of the New York Public Welfare Association. That is a mouthful. What we do is we independently represent all the social service districts statewide. We inform, lobby on their behalf, and advise, them. We joined this guardianship group. It's a really important coalition to garner support for the obviously the budget ask. We are sharing our support for some kind of independent guardianship office. And there are a couple legislative bills that I want to introduce. So stay tuned on those to kind of help our social service districts manage. A lot of times our social service districts are considered the guardians of last resort. We've heard a lot of people discuss today, family, friends, they know someone the best. They're the ones that are probably the most well-equipped to know someone's wishes, what they want. And so a lot of times, if we have someone, we have commissioners of social service districts that are, essentially assigned guardianship for someone. And it's anecdotal, but we've had a couple of circumstances where we didn't have social service commissioners know that they're guardians. There was absolutely no communication between, whether it be, a judge assigning them guardianship, a hospital discharging someone. And, this is really, it's rare, but it's also really sad, having someone under their control for a year, without knowing anything about it. We're not here to vilify judges or hospitals. We understand that they, have something to do at the end of the day. They have to get these people out of their waiting rooms, out of their ERs. So I just wanted to make sure that anecdotally speaking, we have a lot of problems on the local level. Our social service offices are excellent. Their staff are, well-trained. But at the end of the day, this isn't really the best place for some of these people to end up. So, hopefully, thank you to Chairman Levine and the assembly members and staff that are present. This has been an issue that we've been kicking around for, almost a year now. And so we're just trying to find any way that we can kind of take a little bit of the burden off of our social service districts. And so obviously, if there was an independent office, some kind of trained, ethical staff to handle these people, that I think is a goal that we all should, strive for. So thank you for the little bit of time I have.
After you speak, we're gonna open it up for Q&A and discussion, so.
Thank you. There were just a few things that, Danielle's testimony, which was really excellent. I just wanted to follow up on 3 quick things. What you heard from her, and this is what I said to Zayas and St. George when I reported to them a couple of years back. What you heard from her is the reason that the system doesn't completely collapse. Because judges and attorneys like her keep the system afloat because they take and work for free. I want you to think about in what you do for a living. How many of you have volunteered hundreds of hours a year to volunteer for free and work for free on the cause of guardianship? To help a stranger, thank you. It's a remarkable thing, but yet because we're so good at it, the legislature gets to avoid the responsibility. And that's where we are today. That's number 1. Number 2 is she mentioned geriatric care managers. My model, when I got the 250 in Nassau, I went to a woman who was in charge, who was a geriatric care manager, and the president then of a geriatric care manager trade group called ALCA, Aging Life Care Associates. What I did with our 250 was that we appointed ALCA as guardian. She had a group of geriatric care managers who worked in Manhattan, Nassau, and Suffolk. And if they wanted to be part of this, they volunteered for it, and they got put into a wheel, and they got appointed, and they got paid from the grant. We were on track to do about 30 cases, and it worked really, really well. And then Senator Hanlon lost, and our money did not get renewed. But in 2018, the attraction to me of geriatric care managers was, as I said, to move away from the attorneys, number 1. Number 2 is these are the people who knew exactly how to take care of it. So it was really working well when we was the funding. One thing that Danielle didn't mention, she talked about when her ward died. If your ward is fine and you get cancer and you can't work, you cannot get off your case until the judge can replace you. And most times, unfortunately, what we end up saying to lawyers is, I'll be glad to replace you, go find a replacement. So somebody who's had a baby, somebody who's got cancer, somebody who's had a heart attack, they cannot get off a case until we find somebody to replace them. And then it requires motion practice, and it requires approvals, and then from there, right? How many years typically to get off? 4 years. 4 years. Now, when you retire, when you decide to retire, and your boss tells you you can retire, but you gotta take 15 cases with you, please let me know, because I wanna know how that conversation goes. You wanna retire from your job, and that's what your boss tells you. I'm getting upset.
Sorry, I wanted to add something that I didn't have an opportunity to mention, that I think is worth bringing up. It does not solve the problem, but I think it's worth mentioning. So for my nursing home cases, a lot of times it alleviates a little bit of the pressure on the judge if the nursing home resident has pension income. So you can have different forms of income, right? You can have social security, you can have pension. And so why does that alleviate some of the pressure? Because, and social services is on, so I'm happy about that. When you apply for Medicaid for nursing home residents, there is a copay, and it's called NAMI, Net Available Monthly Income. And what that means is that this incapacitated person's income must also go to the facility that they're living in. So to make it easy, if this person gets $1,000 a month in Social Security, 950 of it is the copay that goes to the nursing home, and they keep $50. The agency guardianship programs sometimes accept stipends, and they're $550 a month, $650 a month, $450 a month. And when the incapacitated person only has Social Security income, social services will not amend the NAMI budget to allow for that stipend to be paid. It can only get amended, and that's after many attempts, by the way, fair hearings and all sorts of things, to amend this copay only when there's a pension. And the basis for that in the regulations is that if the need for the guardianship was to get access to the income, then we will allow the guardian to be paid their stipend from that income. And for Social Security, you do not need a guardian. You simply put in a repayee and it's done. It's redirected to the facility. But for a pension, that company usually wants somebody with legal authority to get access to that money. So we have to get a guardian to get it. So DSS will adjust the budget. So a lot of judges get very excited. They look at me and they say, do you have a pension here? Do you have a pension here? Right? Right? Yep. And I love when I review the case file and there's a pension. It could be a $50 pension. I'm still gonna get the stipend paid to the guardian for $450 a month. It's the craziest thing. That should be looked at by the legislature as well. Because years and years ago, I forget the year now, but there was a judge in Queens who tried to simply mandate that social services allows that stipend to be paid out of the Social Security. The case is DNW. I don't know the citation off the top of my head. And it went up to the appellate division and it was, we lost, right? So it's not allowed. You can't direct DSS to do things. But that would alleviate at least some of it. It's the tip of the iceberg, but I think in a room like this, it's worth mentioning.
I don't think I need the microphone, if that's okay. And let me just briefly say how appreciative those of us in the legislature are, because I have not often been at a hearing or a roundtable where so many dedicated people have spoken and there has been no redundancy. I don't know how you managed to do that. So to each of you, thank you for your dedication. Thank you for your passion and your service to our community. I want to just throw a few questions out. On a statewide basis, how many people do we think receive guardianships or guardianship board, whatever the correct term is, statewide? And this is going to be a guess.
1,500.
Yeah. A guardianship, like family, friends,
Statewide,
partners,
yes.
everybody's mentioned.
Right, and that, no, I can't remember when I did my report, I had that number, but I can get it.
All right.
I think it's over 20,000.
That would be my guess.
1,500 a year, 1,500 a year applications.
Very. So statewide, would we be correct in saying it's the largest counties that have the most guardianships?
Queens has the most. And the majority are downstate.
Now, what about upstate? And I'm not talking about, Dutchess County. I'm talking about the more remote or rural areas of New York State.
So those judges told me that they don't have the problem that we have, number one. Number two, in those counties, as was alluded to before, the Commission of Social Services accepts the guardianship appointments and assign people from DSS to do the work.
So do we know, Marty, statistically, are there some counties in which there are next to no guardianships? Given that we know that the commissioners of social services are per se, de facto or de jure,
And not complaining about it. So I don't know the number, easy to get though. But very, very low, very low. There are counties that have more cows than people up there. So there's not,
I grew up in those kinds of.
sorry, I didn't, that's fine, I'm just saying.
So are there some counties in which the number of people who are subject, or covered by guardianships are too low? Are there some counties where it doesn't make sense that there aren't more guardians appointed? Am I making this clear?
I don't think that's point.
If I may, OCSS puts out a chart every year of the guardianships accepted by social service agencies. How many we have applied for, whether they go to Part 36, a private attorney, or a not-for-profit such as EAC. And the counties upstate, there are several counties for several years that had none. But that is just social service driven guardianships. So those figures can be gotten off the OCSS website.
And I would take it that in some of those counties where people live miles apart from each other, that there's not a sufficient amount of know-how or knowledge on the part of the families to go and seek guardianships, especially if they know that's going to be problematic, costly, time-consuming, and traveling 50, 60, 80 miles back and forth to a courthouse is no easy task. So this is, if anything, it seems to me, this is a greater problem than those of us who are in Nassau or Suffolk can appreciate, and we have enough trouble here. But let me ask just a few more questions. To be on this Article 36 list, do the lawyers, do the non-lawyers receive any specialized training?
Very
It's
basic.
limited. It's a, I think, 6-hour course. 6 hours.
Yeah. And it's about really the beginning of the guardianship, the petition, and the paperwork and there's nothing on how you be somebody's guardian for 20 years, his house is stable, medically not compliant, it doesn't have their benefits, doesn't go into any of that.
How to do an accounting. That's what it is.
Yes.
Speaking of those accounts, they have to be filed how many times a year or annually?
Once a year.
Once a year.
Who monitors, who reviews, who supervises those filings?
Court examiner is supposed to.
So a court examiner is appointed at the outset of the case. We have very few of them in Nassau County because they don't get paid often, and it's a lot of work involved. So we began 5 or 6 years ago running what we call compliance calendars to bring into court the grading for court examiners who are filing. And their response typically was that I have too many cases, I don't get paid, I'm gonna get to it. And so in that period of non-filing, think of the risk that the incapacitated person, the ward is at, if in fact they have assets. Because we don't know in the courts until maybe a year after that something is not right in the accounting. But we have no way to really do anything about it, because I think when I left, we had literally 3 people who were court examiners and county was really two.
Who's supposed to pay those court exams?
The county pays based on the amount that's in the guardianship account, the asset, the total asset. So if it's 5,000 or less, I think they get like $150 to do the report, something.
If there's funds, they get paid out of the fund.
If there's funds being paid on, and when we set up a fee, if there's funds, they'll split their bill, and we'll knock it down by 2/3 and pay them. But where the guardianship account is under $5,000 or $10,000, they get paid $2.
What happens to the people who have no assets, where there's a petition for guardianship? Is there a filing fee for those petitions?
Well, I mean, when we bring them, at Stony Brook, we're a state institution, so we don't have a filing fee, but any other, private hospital or private organization would have a filing fee, which I think is around $350.
For the folks who, do the guardianships, who are not attorneys. Are there standardized forms for them to use when they have to go to court? User friendly?
We just went through a process, guardianship with the court, the grant from, federal grant from the Administration for Community Living to create uniform forms across the state because every guardianship part does things their own ways. We worked very hard to create the forms, but the court is not making anybody use them. So the courts are still using their own form.
Well, as a non-attorney, I can't make a motion to the court. I have to either hire an attorney. But people who are not attorneys, there is a process called pro se, that you can bring it. But it's very intimidating and very overwhelming with lots of legal papers, and then you've got to, in essence, in a court, have testimony, and in essence, act as an attorney. So as a non-attorney, I learned this is very intimidating to people. I have people calling me, asking me for help. They know they need a guardian of their loved one. It's a clear case. But going to an attorney and spending thousands of dollars, they don't have to.
And I would say, even if there's a form, which could be very user friendly, once you're in court for the hearing, there are so many complex issues that arise that a layperson would probably have a very difficult time navigating. There are some cases, yeah, so they pretty cut and dry, simple, like an 85-year-old person who gets out and can't survive in their home anymore, but those are not the typical cases anymore.
So the figure of $50 million has been mentioned. And I don't want to be unduly mercenary or venal in the classic sense of those words. But do you really think that 50 million would be sufficient to set up a statewide program?
Well,
Where could we start?
what we're asking for is for the nonprofits who are already doing this work to be funded at 15 million. There's a much higher number being voted to the government to be the appointed guardian. For there to be a new office where it's government employees who are doing the services. That would be much, much more expensive than the nonprofit.
There was something called the Second Development Roundtable, which is a 4 times a year meeting of all guardianship judges and law firms. They last year they created and proposed a draft of a statewide guardian. That was presented to the Office of Court Administration and was included in OCA's 2026 legislative package. I saw the draft proposal and the number was $79 million for the creation of the statewide guardianship program. 79 million. That was the last number that I saw. Now, going back to the use of nonprofits, there the judge, would set the fee. So for the geriatric care manager, I paid $150 an hour. And the pay quarterly based on the number of hours done. Right? No health benefits, no 25% on top, no massive bureaucracy. We found the nonprofits to be very, very responsive and nimble because we had one geriatric care manager in charge of every case. If you want, there are 3 or 4 states that have public guardians. Off the top of my head, Florida, Alabama, Minnesota, and I'm probably missing one other. They typically cap their caseworkers in 20 cases. 20 cases. Okay. You heard here today of individuals who are getting 20 appointments a year. I believe the volume in New York makes a public guardian, statewide public guardian, really, really problematic, both in cost and size and scope. When we have people like private guardians who are approved, and we've used in court for years and years to prove that the nonprofits they work.
Please, don't take them those numbers you were looking for 2023. This is just what I could pull up quickly. The new appointments in 2023, and these are just for cases where basically APS was involved with the whole state, following the guardianship. Statewide, new guardianship appointments were 341. New York City was 65, rest of the state was 276. Total statewide cases, and this is in 2023. 3,565. New York City had 2,325, rest of the state, 1,240. And that's just cases that APS was involved. That's not including like ones with the hospitals.
And I'd like to point your attention to a sheet that looks like this. On the top left, it shows that PSS, Adult Protective Services, is a petitioner only 10% of the time. So that's not taking into account the 44% of family and friends petition, 26 nursing homes, 14% hospitals.
I'm gonna be quiet. Now, just one last thing. Two things, please, don't take any questions that I might pose as suggesting in any way that the non-for-profits are not vital to what we're trying to accomplish. Secondly, Artie, I don't know, but the 79 million that was suggested, did that include the money for the not-for-profits?
No.
Oh, all right, that's good. All right, I mean, and again, I think it's been tremendously helpful.
So, let's start at the bottom that you just pointed out. The non-profit guardianship services at scale. That's 15 million or that be higher?
That's the 15 million. Are there any other questions, or is it, I'm trying to do a progress with the end?
Question. With, I appreciate all of some members of these questions, and I appreciate all of you dedicated to service, commitment, perseverance of all of you. But that 79 million, that's just to start having this government facility.
To create the bureaucracy.
Right, so it's creating that, but then more money, the 15 million on top of that would be for the nonprofits, but then on an annual basis, what is the estimate of how much would be needed annually?
The proposal was geared to the existing cases. So the idea is, it's a one-shot deal, and then after that, it's just to maintain this department. Just like you would maintain DMV or CA or whatever. So it's made it.
Okay, thank you.
Yeah, that proposal includes the government agency hiring attorneys and caseworkers and, yeah.
There's one other question, but so the 50 cases and stuff, that's part of the county budget?
The county provides me with funding for up to 50 cases. That's,
The only county that does that?
correct.
So
For us,
Nassau County doesn't provide any money.
not for us.
No, when we lost our grant, we rely on the EAC as the public guardian. So whenever a judge has nobody to appoint, we call the EAC. I mean, first we would try people like Danielle, and then if that doesn't work, we would then go to the EAC and hope that they have space.
Nassau County pays our Nassau DAC program. Okay, for our.
There's an RFP, and they have to be your board.
I'm gonna grab the mic just so I want to make sure that I don't know how they're hearing on there. And I'm just gonna wrap up quickly. First, thank you everybody for being here today. This means a lot to us. Obviously, it's an issue we've been working on for many, many years. The recommendation that Andy, the Guardianship Access New York Coalition, is putting forward is for a statewide initiative of nonprofit guardians. So we're asking for 15 million to serve 1,500 people. This would also create a workforce of over 120 people who are trained in various skill sets to do this work. I'm talking staff attorneys like Allison here, caseworkers, benefit specialists, finance managers. It would also include a system for data tracking of all of the clients that are served by this network, because we don't have good data. We have some data on conditions and appointments. Nobody's tracking outcomes, what happens over the 20 years, what, like the stories that Allison told today, those aren't being captured at scale and so part of this network would be to collect that data from everybody that's funded by this pot of money on every single client. It would also include quality assistance and quality assurance, and technical assistance. We've already started without funding, meeting just to talk about specific cases, share best practices. We meet monthly for that. As I said, $67,000 per year per client would be saved mostly in Medicaid costs, keeping people out of institutions, out of hospitals, keeping them in their communities, times 1,500 clients is over $100 million. So it makes sense that way too. And as Matt mentioned, the New York Public Welfare Association has some bills that they're planning to introduce. We're also working on a bill with Senator Clear that would, the legislation would establish the statewide initiative of nonprofit guardians. We'll have that number to share as soon as it's released for introduction. Obviously, this is a topic that everybody in this room is incredibly passionate about, and we could talk about for a very long time. But I just thank you so much, Assemblymember Levine, for helping us put this on today. For everybody in the room for spreading the message and sharing this often neglected story that is just not understood.